We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you and good morning. Good morning to you both. I'm going to call the first case on today's list, which is Commonwealth versus RAYSHAWN NUNEZ 2019-1748. Before we begin, I'd like to introduce the panel to you today. I am joined by Justice William Meade and Justice Amy Blake, and my name is Vuono. I'm sure I don't need to remind you that you each have 15 minutes for your argument, and you may take less if you feel you can make all of your points in less time. That's fine. You can be assured that we have read everything that you have submitted to us. I'll also remind you that there is no rebuttal. And finally, although I don't want to jinx today's argument, we sometimes have had some technical difficulties. And if we do, please be patient with us, and we will be patient with you as well. So with that said, Attorney Rose, please begin.
Good morning, and may it please the court. Rachel T. Rose for RAYSHAWN NUNEZ. As the Commonwealth's brief concedes, Nunez's guilty plea was unknowing and therefore void, and the case must be returned to the trial list. Rule 12 requires that when a defendant agrees to plead guilty because he has reached an agreement with the Commonwealth, the judge must either sentence according to the agreement or allow the defendant to withdraw the plea. The judge's intended disposition, as stated repeatedly on the record to Nunez, was both compliant with Rule 12 and pitched toward her intended purpose of ensuring his good behavior during the next 3 weeks out on bail. If he was arrested or failed to appear for sentencing, he would lose the benefit of the Commonwealth's concededly generous plea agreement and must take his chances at trial. That she intended to keep the plea but violate the agreement in that circumstance was never plainly stated on the record to Nunez or even to his counsel. Without knowing what he was agreeing to, his plea is void in a constitutional sense. Knowing what the plea connotes and its direct consequences must surely include the conditions under which you've given up your right to trial. His not understanding the deal the judge proposed means the plea is invalid regardless of whether he would still have agreed to it if she'd spelled it out. But even if she had made it clear, this case would still require a remand. Denying Nunez his promised right to withdraw when she rejected the agreement would still be error as a straightforward violation of Rule 12 that's subjected to a prejudice analysis. That prejudice is measured by whether he would have taken the opportunity if she'd given it, not whether he'd have agreed to what she proposed in the first place.
We don't have to reach any constitutional questions if we find a violation of Rule 12, right?
That's correct. The counsel immediately moved to withdraw the plea when the judge made clear what she was going to do makes it indisputable that he would have taken the opportunity if she'd given it. As the Commonwealth argues in its brief, Rule 12 requires that the opportunity to withdraw be given at the point when the plea judge rejects the agreement. The judge's comment that she would not have violated the agreement for an arrest that she thought was without basis, and counsel's comments over whether custody from probation violation after a drug test followed by new charges really constituted an arrest, both demonstrate that piling conditional waivers onto a conditional plea is ultimately incompatible with due process. Permitting them either invites endless appeals or creates a loophole that swallows Rule 12 entirely. By not allowing Nunez to withdraw his guilty plea and then sentencing him outside the plea agreement as if he had already been to trial and lost, the judge's actions served to unfairly deny him the benefit of Rule 12. Nunez was deprived of the trial he was entitled.
No, nothing.
Nunez was deprived of the trial he was entitled to because his reliance of a promise from the Commonwealth that the judge refused to honor based on, in turn, her own assessment of the validity of the new charges against him.
Attorney Rose, do you read the Commonwealth's brief as agreeing with you, at least as to the Rule 12 issue?
I read it as agreeing with me as to both Rule 12 and the constitutional issue.
And I recognize, and I want to be careful here, if it's outside the record, I don't want you to do that, but has there been any effort to resolve this short of this appeal?
Just what was done at the trial level that you've seen. Because only the allegations of what happened after Nunez left the plea hearing separated him from his right to trial by jury, the plea judge ultimately abused her discretion by denying the motion to withdraw. That she said she wasn't using the new charges to determine his sentence can't ultimately be true when without them everyone agrees that the sentence would have been the 3 to 5 he was promised. Due process does not permit what amounts to tricking a defendant into giving up his right to trial, and it doesn't permit sentencing based on new allegations. This case must be remanded so that Nunez can either receive the benefit of the agreement on which his plea rested or be given the trial he was entitled to.
What do you mean by giving the benefit? Are you saying they're still entitled to plead guilty and receive a 3 to 5 sentence?
I believe it is within this court's power to remand, and with instructions that the judge either revise the sentence to the 3 to 5 he was entitled to, or withdraw the plea and return it to the trial list.
Well, that's really up to the Commonwealth.
Yeah. Yeah. We would be overstepping the the power of the judiciary there. In other words, what the judge did say and said fairly clearly in the very beginning of the colloquy is that if she exceeds the sentence, that the defendant would be entitled to withdraw his plea, which is standard, of course, information. And she exceeded the sentence, and so he now has the your point is that he now has the opportunity to withdraw his plea, and the Commonwealth agrees with you.
Yes, exactly, Judge. There's no denying that the crimes as alleged by the Commonwealth are horrific, and there's certainly no guarantee that allowing him to withdraw the plea will ultimately result in a lower sentence for him. But it's his right constitutionally, and it's his right under Rule 12. If there are no other questions.
No, I think that the case is very straightforward, and you briefed it well. And any questions from the panel? No. Thank you very much, Attorney Rose. Well, now I hear from the Commonwealth, and perhaps the Commonwealth can start by telling us why maybe there was no agreement to the motion to withdraw the guilty plea in the first place.
Your Honor, I don't know that I can answer that question. I think having sort of relooked at the rule, and I expect that Attorney McGowan, who is the trial attorney, would agree or does agree that his motion to withdraw should have been allowed. I think that all parties were proceeding in good faith with this understanding that if the judge was in error in doing this, that the parties would agree to the 3 to 5 that had been agreed on beforehand. And so
that's something that's not in our record, right? That's something between the defense attorney and the Commonwealth, correct?
I think if you read the transcript of the actual imposition of sentence, it seems as if all the parties were saying, look, the judge was saying, if I'm wrong here, no harm, no foul, he's still going to get the 3 to 5, and nobody was disagreeing with that. But yeah, I think that it just to get to the original question, it was in error to not allow him to withdraw his guilty plea in the Commonwealth.
Where in the transcript you're interpreting that? Because my interpretation of what happened at the hearing is simply that if there was an error, the defendant would be permitted to withdraw his plea, not that he would be entitled to any particular sentence.
No, I'm sorry. I'm talking about on May 3rd.
Yeah.
Hold on, if I can just have 1 second.
Sure. I'll bring it up myself as well.
I think it's on.
That was sentencing.
Right.
Right. Where Attorney Doolin, now Judge Doolin, asked that the court sort of hold off until he gets a copy of the transcript.
Right, because he wanted to be sure that that judge had actually told the defendant that if she were to exceed the recommendation, he would be able to withdraw his plea.
Right.
And he just couldn't recall if that had actually been said.
Right. And the court's response was, hey, if it turns out that you're right and I'm wrong, this will be resolved within the 3 years that he would have received anyway. Meaning, and I interpret that to, and let me just get you the specifics.
Now that I recall, I just have to say that I think that's susceptible to a different interpretation.
Okay. All right. In any case,
it doesn't even matter. I mean,
I don't think it does matter. I think that at the end of the day, once the court indicated that it was going to exceed the plea agreement, the defendant had an opportunity to withdraw his plea, which he wasn't given the opportunity to do that, or the judge rejected it when he was asked to do that on May 3rd, and therefore it's a plain violation of Rule 12D, and he should be entitled to withdraw his plea and proceed accordingly. I expect that the plea agreement would still remain a potential for the court to consider and impose. But the starting place is that he be able to withdraw his plea and resume accordingly. There's I think what's frustrating about it is that it does seem to me as if all the parties were acting in good faith, at least in a understanding that they were doing what they thought was the correct procedure, and there isn't a great mechanism for the courts to stay an imposition of sentence that would allow them to have any sort of incentives for a defendant to sort of remain within the law. I think that's a gap, and we're all sort of winging it in the trial courts. But I think unfortunately the solution here is the withdrawal of the plea. And unless there's any other questions, and I'm sorry I stumped you with the.
I just have an observation. I know that you didn't write the brief, but I've been doing this for a long time. I've never seen the Commonwealth write an entire brief copying all the defendant's arguments to concede error. And the district attorney can allocate her resources how she sees fit, but in the future, you might want to know that you can send a letter that concedes error, and a panel of this court will review the case.
So I did take advantage of that, I'd say about a month ago. And I'll say that was news to some of the members of the appeals unit that we could do that. We have been asked to brief things even if we do concede, but I am more than happy to spread the word on that, and certainly will.
Okay.
Thank you.
No other questions. I'd rest on
No, I see the panel has no further questions. Thank you both very much.
Thank you.
We'll take the case under advisement.
We are live.
Thank you very much. Good morning and welcome to today's remote sitting of the appeals court. This case is Commonwealth versus Jones. The number is 2020-0048. Before you begin your arguments, I would like to introduce the panel to you. I'm joined today by Justice William Meade and Justice Amy Blake, and my name is Vuono. I don't think I need to remind either of you that you each have 15 minutes to present your argument and that there is no rebuttal in the appeals court. I would like to say, however, that upon occasion, we experience technical difficulties. If we do, we ask you to be patient with us, and we'll be patient with you as well. With that said, Attorney Croha, you represent the defendant in this case, so please begin your argument.
Good morning, Justices. Yes, Kim Croa for the defendant, TAHJAY D. Jones. And may it please the court, this is a close case. It was described by the judge at the end of the Commonwealth's evidence as being just over the hump with circumstantial evidence. So just for a quick recap, it's a case about a 20-year-old kid who panicked when he started to get pulled over by the police. He initially slowed down. The police started to pull behind him, hadn't stopped their car, hadn't gotten out, and he made the unfortunate decision to drive away from the police. He drove off, and those actions resulted in a car crash where he damaged 7 vehicles. And then Officer DeGrave observed him jump out of the vehicle, not carrying anything, not carrying a backpack, not intending to get rid of the backpack, and run off. The officers who had been following him apprehended him, and then after that point, they observed a backpack outside the vehicle that had a firearm in it.
Now, there is a photograph of the backpack outside the vehicle that was introduced to the jury, correct?
That's correct.
Okay,
yes.
And so you don't dispute the fact that the backpack was right outside the driver's side door where your client had, right after your client left the vehicle and started to run.
Correct. No, that's not in dispute. The argument with respect to the location of the backpack is that the passenger side door was pinned shut. A witness to the crash told one of the police officers that he saw a passenger get out of the vehicle. And so a reasonable view of the evidence would be that the passenger got out of the driver's side door because his door was shut.
Well,
and
why would we be taking a reasonable view of the evidence and not looking at the evidence in the light most favorable to the Commonwealth?
Well, whether or not there was a passenger, and I'm I'm sure Attorney Wakeford can come in on his point, but it wasn't there didn't need to be a passenger. There didn't need not to be a passenger for the Commonwealth's argument. So whether there was or there wasn't plays into some of the arguments that we have, but I don't think that the court needs to determine that there either was or there was not a passenger in order to.
Nor would we, because that would be a question for the jury, not
Right.
for us, right?
Of course, yes. And of course, the standard is that the evidence is taken in the light most favorable. But for this collateral issue, I think that for some of the arguments, it could be looked at in either way for what was presented to the jury. And I'd like to move into the errors that occurred during the trial, because I think in this close case, there were 3 particular issues that happened during the trial that would require a reversal of the conviction, because those errors created a substantial risk that there was a miscarriage of justice, that the defendant was convicted for something other than the limited evidence that was presented on possession. So the first issue was the vehicle damage. The jury were presented with 12 photos and extensive testimony of damage to vehicles, broken mirrors, a sideswiped side of a minivan, a vehicle being pushed up on the sidewalk. And then they were told at the end of that the defendant was only charged with the crimes on the complaint, all of which were possession related. So these are actions that took place at the same time. The vehicle damage took place at the same time as the firearm was found.
But why don't they go to the nature of the flight? He didn't just drive away peacefully at a high rate of speed, right? He was crash them up with 7 cars.
Right. And I do understand that the evidence of the crash and the damage, it was entwined with the events, and it was relevant to what happened, and certainly getting away.
Isn't that the end of the story then?
Well, even if evidence is relevant and allowed to be admitted, there's still an obligation to make sure that it's not unduly prejudicial. And together with
they're photos of the crime scene.
Right, they're photos of the crime scene, but the bad act instruction that was given to the jury, the judge did tell the jury that they couldn't use evidence of other bad acts as substitute for proof. So that was there, but the confusion, it took place because the jury was also told that there weren't any other charges for any other crimes. So the jury could have believed that there was absolutely no punishment for causing all this vehicle damage, of which they saw all this evidence. And they heard the prosecutor talk about in the closing argument.
So you've couched this in terms of ineffective assistance, right?
Right.
So, but we have no motion for new trial. We have no idea what decisions counsel was making. We have no findings by the judge, and you've admitted that they're inextricably intertwined with the evidence of the crime scene, and could be understood as part of this flight. How can we possibly say that counsel was ineffective indisputably on this record?
Well, if you look at the record, the record shows that the defendant had pled guilty to the vehicle charges before the trial started. So you have that's already been done. The defense counsel did, during the back and forth over this plea, concede that yes, the evidence about the bad acts could come in. There was discussion about the unduly prejudicial, but I think the error is clear on the record that there should have been something more with the bad act instruction. There should have been something more.
You're carefully calling them bad acts, as the case law refers to prior and subsequent bad acts. These are contemporaneous bad acts.
Right.
These are part of what happened, and the Commonwealth gets to put the entire picture of the crime when relevant, which you've conceded, before the jury. So when you said that he's already pled guilty to the motor vehicle offenses, are you telling us that those facts are then excised from the trial equation?
No, Your Honor, that's not what I'm attempting to say. What I'm trying to say is that they were in there, the jury heard them, but because this is a different case, usually when we talk about bad acts, it is something that happened before. And so a jury it would be quite reasonable to think that even though they're not being charged with it now, they were charged with it at some other point, or in some way that bad act was being resolved. But here they happened at the same time, and all the jury has in front of them are the possession charges. So what happened to the vehicles? What happened to all this damage that was caused? Is there any punishment whatsoever to the defendant? The jury has no information about that. And so the undue prejudice in this case is
They do have the judge's instruction that they can't be substituted for guilt in the gun case, though.
Right, that was in there, and the jury was instructed with that. But in the context of the close case and the confusion created by having no information about any punishment for those acts, that's where the issue with that error came in. And there are no other questions on that. I'll move on to the next error that came from the prosecutor's closing argument. The prosecutor argued in closing about DNA evidence, and the prosecutor said, well, there was some DNA on the sweatshirt, but it wasn't suitable for testing. When the Commonwealth has conceded that there was DNA on the sweatshirt, but the testimony at trial was that it was suitable for testing, but that there wasn't a match. And then the prosecutor went on to say that there was also direct evidence linking the defendant to the firearm. The only evidence about the firearm was a fingerprint that was on it, which was not the defendant's. So the police never attempted to find another owner of that fingerprint, just as they never attempted to search the DNA that was on the sweatshirt to find the owner. So the combination of those two statements, the incorrect statement about DNA on the sweatshirt and the direct evidence, could have created a perception and created a substantial risk that a jury could have believed that there was some other evidence between the firearm, or more likely the sweatshirt, that linked the defendant to the firearm that was wrapped inside the sweatshirt at the time it was found. And the third error that happened, it goes to the close call as far as the possession instructions. So the judge instructed the jury on possession. They went out to deliberate. They came back and they asked for written instructions on the possession, showing that it was a material issue in their deliberations.
So you're saying that the evidence was not sufficient to show that the defendant knew the firearm was loaded. Is that what you're getting at?
Right. So on the ammunition charge, there's no evidence that he ever saw the firearm. The firearm was inside a sweatshirt, inside a backpack, and
there's no evidence that he could see it inside the backpack. But if the jury determined that he possessed it and it was a revolver, then one can infer from those circumstances that he knew it was loaded.
But the knowledge of the ammunition is a separate requirement. And the fact that...
Well, I'm sorry, I didn't mean to interrupt you. Please finish what you were saying, then I'll follow.
Right. So the fact that it was inside the sweatshirt, inside the backpack, the Commonwealth still needs to prove that there was some evidence he knew of the ammunition. And so we just don't have that in this case. We have the backpack and we have the firearm inside the sweatshirt. So
well, let me ask you this then. There are two exhibits that were introduced at trial, 32 and 33, which appear to me to be the photographs of the firearm. Do those photographs show that the firearm, that the revolver is loaded and that you can see the bullets as you would be able to in any other revolver?
Yes, and if the firearm was on the passenger seat or something to that effect, I think it would be a different question. But because it was wrapped.
Okay, so we can agree there's no dispute that by a visual inspection of the firearm itself, you can see that it's loaded. You can see the ammunition.
Correct. I'm not disputing that.
Okay.
But so the possession instruction, the judge instructed the jury, the Commonwealth asked for a joint control instruction, and the judge gave that. There is a portion of the jury instruction that talked about how a jury cannot convict a defendant of guilt of possession by association. So that can be association with a place or with a person. That part of the instruction wasn't given. The defense counsel didn't ask for it either. So that's couched in both ineffective assistance and the error and omission from the jury instructions. But the Commonwealth has pointed to the Perez case that talks about guilt by association isn't actually required as long as the rest of the instructions are proper. But that case only dealt with association with property, there being an apartment. In this case, we have property and person, and this is where the passenger comes in, that the associated person would be the passenger of the vehicle. And then the location would be in the firearm.
But doesn't the associated person have to be in control of the weapon for this instruction to apply?
Right. So it would be if there was enough that the passenger was the one who has controlling the firearm, which I think is a reasonable.
Even if believed, the witness just said they saw someone leave the car. They didn't say they saw the other person in control of the weapon.
Right, but the officers testified that they saw the defendant get out of the vehicle and he didn't have the backpack with him. So that would mean that the passenger, if they got out, would have either knocked it out or would have brought it with them and then left it there when they took off running.
But no view of the evidence shows this passenger, whether it existed at all, to be in control of the weapon.
Right. And again, this does go to the view of the evidence, but I think a reasonable view of what happened is that the defendant learned of some contraband, whether it be a firearm or something else, at the time he started to get pulled over. And that's why he took off and he got scared and panicked, but he never intended to exercise control over the firearm. He tried to get away from it. He didn't try to. He evaded the police for a portion of time during the car drive. He didn't try to get rid of the firearm. So the Jefferson case.
He twice evaded the police at such a high rate of speed they had to stop the pursuit for safety purposes. And then he again fled after he crashed.
Right. Neither of those times did he try to get rid of the firearm while he.
Well, you could say he was trying to distance himself. A reasonable trier of fact could reasonably infer that he was trying to distance himself from the firearm.
Right. And if he knew it was there, he very well probably was, because he didn't want to get convicted by association with the firearm being in the vehicle. But he was, I think these combination of the points create a substantial risk for the jury that they convicted him based on these items and not because of the actual elements of the possession. Now, if there's nothing more, I'll rest on my brief for the remaining arguments.
I'll just check with the panel. Justice Meade, Blake, no further questions. Thank you very much.
Thank you all.
Okay, we'll turn now to the Commonwealth. Attorney Wakeford.
You have to unmute yourself.
Thank you, Justice Meade. May it please the court, good morning. My name is Donald Wakeford. I represent the Commonwealth in this matter. Affirm the defendant's convictions because the evidence was sufficient to convict the defendant on the charges. There was no error in the judicial instructions because the instructions, when analyzed as a whole, adequately instructed the jury. There was no ineffective assistance of counsel because the bases put forward by the defendant are meritless, and the prosecutor's isolated misstatement and closing arguments did not give rise to a substantial risk of a miscarriage of justice. This is a case where the defendant was convicted on evidence that he, as Justice Meade just mentioned a moment ago, attempted at all costs to escape apprehension because he was aware and was in control of a firearm inside the vehicle. The firearm was recovered from a bag immediately outside of the door, which the defendant exited as he.
Other than the location, Attorney Wakeford, other than the location of the backpack and the fact, of course, that the defendant was a driver, was there anything else inside the backpack that indicated that he was the owner of the backpack?
No, Justice Vuono. The Commonwealth's case did not rest upon the contents of the backpack tying the defendant to the gun. The Commonwealth's case largely rested upon the evidence of flight, and not just flight, but headlong, reckless flight that indicated a consciousness of guilt and an awareness of an awareness and control of the firearm. So no, there was no evidence within the backpack that the Commonwealth relied upon to tie the defendant to the firearm. This was a case where the Commonwealth presented evidence to the jury to allow them to infer that a person most likely is acting this way because they are aware they are going to face serious consequences if they're apprehended. This was not a case where anything happened except that a minor traffic violation was giving rise to a common traffic stop. And at that point, there were multiple instances of the defendant fleeing at speeds that would be more appropriate on an interstate and not in a residential portion of Dorchester where the speed limit is 25 miles an hour. This, of
Wait,
course,
for what?
ultimately.
What evidence is there, the total sum of the evidence that there was a second person?
I always hesitate in oral argument to maintain that I am providing the total summary of the evidence entirely, but I will do my
Fair
absolute
enough.
best here. And of course, if there is an inaccuracy, we will correct it. However, my understanding total of the evidence that there was another person in the vehicle was a statement attributed to an unknown bystander at the scene, given to an unknown officer. This was really hearsay evidence. I cannot state in my place at this time that I recall exactly how it entered the trial. I believe it was during cross-examination. But we had no witness come forward and say, I saw a bystander. And we had no officer come forward and say, a bystander told me directly that they had seen another passenger. Instead, it was officers testifying that other officers told them, we've gotten a report there was another passenger. Then there was a canvassing of the neighborhood and an exhaustive search of the area immediately, and there was no indication there was a passenger in the car, in the vehicle. Additionally, the defendant was apprehended a very short distance away from the vehicle when he attempted to flee on foot, and a very short distance in time and physical space. And then the officers testified they saw no other person exit the vehicle. So that is stating in my place now, that is what I believe is the only evidence that there could have possibly been another passenger. So what we have here is a situation where only one person was seen as exiting the vehicle. A bag is recovered immediately next to the door that person used to exit the vehicle, and within it is a gun. This is after this person led the police on a high-speed chase. This evidence together was more than competent to provide a basis for the jury's verdicts and should be affirmed. With regard to the other errors or purported errors put forward by the defendant, the judicial instruction was adequate because the judge covered all of the bases that were enunciated in Perez. In fact, at pages 97, 98, and 99 of the second volume of the trial transcript, we see that the judge gave exactly the instructions that this court noted in Perez were adequate to instruct a jury on possession when combined with the other portions of the almost verbatim model jury instruction given in this case. With regard to ineffective assistance of counsel, the Commonwealth believes that neither of the, as Justice Meade stated earlier, on the record before us, there is no way to demonstrate ineffective assistance on the part of trial counsel in this case. And finally, with regard to the prosecutor's isolated misstatement in closing arguments, this statement, which came in the midst, was one statement in the midst of an extensive and detailed closing argument, which did not lead to an objection at the time, indicating that its context was not inflammatory.
Where did it come from? I mean, she says out of the blue that they couldn't match the DNA to anything, which is patently false.
I stand here forced to speculate, Justice Meade. I believe we in a footnote, I believe 5 or 6 of the Commonwealth's brief, I believe this was a heat of the moment transposition of two concepts, where there was evidence that had come in at trial of a partial print on the gun that had been unable, there was simply not enough there to do an adequate test of that evidence. And I believe the prosecutor was attempting to discuss that evidence, and in the midst of closing arguments, accidentally said DNA instead of prints. That is my supposition. However, it is unquestioned. We are not before this court trying to say that statement was not incorrect. No. It unquestionably was. However, we just believe in the context of the closing argument as a whole, where this is the only time it's mentioned, and the prosecutor actually went to great pains to go over each and every item of physical evidence associated with the vehicle and what that meant for how the defendant had to exit the vehicle. I believe in that context, especially when we see no objection, that it's clear that this does not give rise to a substantial risk of a miscarriage of justice, particularly when taking into consideration the judge's other entirely adequate and lawful instructions as to what the evidence is and what the jury can lawfully consider. Unless there are any further questions,
I have a question, just a minor question. That is, it seems that both of you have given us all the photographs of the vehicles. There's an appendix filed by the defendant, and there's a supplemental appendix filed by the Commonwealth, and no one included the exhibits 32 and 33, which are the photographs of the firearm. And directly raised in this case is whether or not the defendant had knowledge of the firearm was loaded. And after Commonwealth versus Civello, it seemed to me pretty important to let us know whether or not you could actually, whether or not the ammunition was visible. Now here, of course, candidly and appropriately, defense counsel has told us that you could see the bullets in the firearm. And I'm assuming, of course, that you agree with that.
Yes, Justice Vuono, yes.
All right. So since we have an agreement on that, I'm going to ask the panel. I don't think we need to see those exhibits unless you would like to, either one of you. I'm not seeing no, and I'm seeing a no. All right. So I just say in the future, it would have been, I think it would be helpful to include that.
Thank you, Justice. Of course, that is entirely true, and that is an oversight entirely on my part. I will also add that there is a piece of testimony from the trial where one of the officers who recovered the firearm from the backpack indicated in testimony that you could clearly see that the firearm was loaded. However, providing this panel with the photographs to back that up, of course.
It looks as if he must be referring to the ammunition, but his testimony is not crystal clear. There was no question to it was not crystal clear. And of course, the jury had the firearm and could see it himself. But as you know, by doing appellate work, what's going on in the courtroom doesn't always get translated on paper in black and white for us to understand. But it's not an issue anymore in this case. We understand where we are. It's a revolver, so I don't need to belabor the point.
Well, I fully understand and will take that forward with all deference appropriate. Thank you very much. Are there any other questions which I can address for the panel this morning?
No.
If that is the case, the
the
Commonwealth will rely upon its brief, and thank you very much.
Thank you both very much. Thank you for both your arguments. They're very helpful on both sides, and I will take the case under advice.
We're live.
Okay, thank you very much, and good morning to you both. I'm going to call the case first, Commonwealth versus David Masonette, number 2019-1436. And then I'd like to introduce the panel to you. I'm joined today by Justice William Meade and Justice Amy Blake, and my name is Vuono. I don't think I need to remind either one of you that you each have 15 minutes for your argument and that we have already reviewed everything that you have submitted to us, so you can get right to your most salient issues as soon as you start. And I will remind you, however, that there is no rebuttal in the appeals court of Massachusetts. Next, I'd just like to alert you that if we have any technical problems, which we hope we do not, that we will be patient with you, and we hope that you'll be patient with us, and we'll get them resolved as soon as possible. With that said, Attorney Gauthier, the floor is yours.
Thank you, Your Honor. May it please the court, my name is Edward Gauthier, and I'm appearing today on behalf of the defendant appellant David Maisonette. As you well know, Mr. Maisonette was convicted on 2 counts of indecent assault and battery under 14 for sexual assaults against his stepdaughter victim. We've raised 5 claims. 4 of those 5 claims actually deal with the testimony of the victim's mother, who testified for the defense. But in reality, she was not a good witness for the defense, as the court can see. It was clearly an error for trial counsel to call her. And her testimony was problematic in a number of ways. First, she was able to give irrelevant emotional testimony about a pretrial hearing. She was able to talk about wanting to kill the defendant. She was also able to relay a second complaint. And more importantly, her reaction to that second complaint, which was kicking Mr. Maisonette out of the house. The testimony of the mother, which was horribly, horribly prejudicial for the defendant, was error in several ways. First, it was error, it was ineffective assistance of counsel in the first instance for trial counsel to call her. An attorney has an obligation to safeguard his client from having a witness like this take the stand. And given the relationship between the mother and Mr. Maisonette, and given her prior testimony, it should have been very clear to defense counsel in this case that calling her would not elicit anything helpful. And in fact, nothing at all from the mother was elicited that was in any way helpful to the defense.
Well, didn't she wasn't the plan to get mother to contradict the victim about the permission slip?
It appears that the one thing that defense counsel at very best hoped that he would get out of the mother was a statement from her that would have contradicted a small part of the Commonwealth's case. And that was that after the second most recent sexual assault, that the victim had gone into the mother's room and spoken to her about a permission slip. So at very best, defense counsel anticipated that possibly he may get a very uncooperative witness to acknowledge a slight inconsistency. Now,
Mr. Gauthier, though, the second piece of that potentially was that the delayed disclosure of the 2012 incident, that the child had not reported that to her mother, right?
That is true, that there was evidence before the jury that there was no disclosure of the 2012 incident until 2016. So
those are two things that defense counsel hoped to elicit, right?
Well, the failure of the victim to disclose any sexual abuse prior to 2016 did not have to come from the mother.
Well, but this was completely a credibility case, right?
100%.
And the more people that you can have testify that the victim didn't tell them about it, doesn't that go to the victim's credibility?
Not if it's easily explained as to why there was no disclosure. As we know in our first complaint doctrine, there are a myriad reasons for why a victim discloses sexual abuse when a victim does so. A delayed disclosure between 2016 and 2012 does not in any way speak to a lack of veracity on behalf of the
But certainly once the evidence is in before the jury, counsel can make an argument exactly along those lines,
Right.
which he did, or she did, I forgot.
Counsel did during closing argument point out three inconsistencies. Essentially, the three inconsistencies counsel pointed out were over versus under the clothing in the 2012 incident, whether mom was home or at work during the 2012 incident, and when was the first disclosure? Was it in 2016 or in 2012? The real problem that we have with mother's testimony, beyond it being very damaging, and the testimony about the emotional stuff from the pretrial hearing, wanting to kill him, is the biggest problem we have is how the Commonwealth used that during the closing argument. During the closing argument, the Commonwealth asks the jury to draw inferences that the defendant is guilty because of a mother's emotional state and because the mother kicked him out of the house, essentially arguing that these sexual offenses must have happened because if these offenses didn't happen, mom wouldn't have taken steps to protect her daughter. Mom wouldn't have kicked Mr. Maisonette out of the house. Mom wouldn't have had to be arrested and being brought to court. And the Commonwealth acknowledges in its brief that there were improper inferences that the Commonwealth asked the jury to draw.
We'll ask him about that, but counsel is allowed to argue based on the evidence. All of these things you mentioned are in evidence why the victim's testimony should be believed, even if those circumstances include kicking the defendant out of the house.
We do not, it is not our position that the fact that the mother kicked the defendant out of the house, it is not proper for the Commonwealth to argue that the victim in this case should be believed because the mother reacted to the complaint the way that she did. We don't feel that that goes, I mean, this case, as we agree, is 100% about the credibility of this 13-year-old victim. The fact that the mother, once told about the assault, kicks the Mr. Maisonette out of the house, that doesn't go towards her credibility. That doesn't go towards whether the jury, who is the fact finder, should believe her. The fact that the mother believed her, the mother kicked Mr. Maisonette out of the house, that doesn't go to the victim's credibility.
Can I ask you how it is that we're reviewing the closing argument claims? Because the Commonwealth suggests that at trial, defense counsel argued that the error in the closing was burden shifting, that you're arguing something different here, and therefore we're looking at it as substantial risk. And in addition to that, contrary to what you've claimed, that a curative instruction on this issue was not requested. So again, it's a substantial risk analysis. Can you respond to that?
After receiving the Commonwealth's brief, I went back and very closely parsed what happened during the closing argument and the conversations. And the defense counsel did make an argument for why there should be some steps taken by the judge, but not on this point. The defense counsel did not object to the closing argument the way we are presenting the argument on appeal.
So you would agree it's substantial risk?
I would agree that defense counsel did not lodge an appropriate objection, yes.
I want to know where in the record counsel asked for a curative instruction.
I went back and I looked and I did not see.
Why did you make that argument in your brief?
I must have I must have seen it, but I did go back and look and I did not see. I did not.
And you sent a letter correcting that mistake after you read the Commonwealth's brief.
I did not. But I do agree that upon a more careful inspection, that there was no request for any action to be taken on the issue that we are raising in this brief.
Okay.
The only issue that we've raised other than issues that surround the mother's testimony is an objection to a single prior bad act that occurred between 2012 and 2016. And of course, the court has discretion in considering whether to allow prior bad acts in, but the prior bad act has to go to something other than an inference that the defendant is a bad person or is likely to commit a crime. And I've looked
to that end though, counsel, doesn't it go to the relationship between your client and the victim as well as his ongoing sexual interest in her, particularly given the timeline here?
Well, I did cite the case that goes directly to the sexual interest. And there's no timing at all with regard to this, this uncharged prior bad act. We don't know if this happened in 2016, 2012. We don't know where they were living. We don't know what the relationship was at that time. There's so much.
Well, we know it was before 2016, right? That was the last event.
Of course, there was no contact between Mr. Maisonette and the victim after the 2016 allegation. So it must have happened at some time in the timeline of their lives between, so the evidence was that Mr. Maisonette started a relationship with mom around 2009. So their relationship was about 7 years. So all we know that is at some point in those 7 years, on one occasion in a car, we don't know when, that Mr. Maisonette put his hand on the victim's thigh. That's it. There was substantial evidence that came in during the course of the trial about the relationship between the parties, the victim, the sister, the mother, Mr. Maisonette, how he was a stepfather figure. Now, looking at how probative or how relevant is a single incident, not a pattern of conduct, but a single incident at an unknown time at some point in those 7 years, how probative of that?
Well, it's the pattern, including the two charged events and the uncharged event. The uncharged event is one in which he says he touched her thigh because he liked doing it. That's certainly
is correct.
probative of not only a state of mind, but a pattern of conduct.
Well, the state of, we object to any consideration of it for state of mind. I don't believe the state of mind of the defendant was a live issue at trial. This wasn't a case of why was he touching her or what interest did he have in touching her. The sole issue at this trial was, did he put his hands on her? So the only inference that can be drawn from the prior bad act is he puts his hands on her, which just goes to his propensity to commit the crime charged.
Can I ask you about the second complaint for a moment?
Yes.
We know that certainly the victim was not asked that question, right? It came out spontaneously. And there's an argument to be made that trial counsel for your client exploited that on cross-examination. Certainly the DA didn't follow up on it. And at best, it was brief and fleeting, as the case law suggests. So tell me why you think that your client is entitled to relief on that particular issue.
Well, although the testimony regarding the second complaint was brief and fleeting, and by that I mean the victim told her mother about the sexual assault, that was brief and fleeting. Part of the first complaint, or in this case, the second complaint, is the listener's reaction to the complaint. And the listener's reaction to the complaint in this case was, Mom kicked Mr. Maisonette out of the house. While it was brief and fleeting during the course of the testimony, it was exploited very well by the Commonwealth during closing argument. The Commonwealth stressed during closing argument that this second complaint occurred. Mom reacted to the second complaint the way she did. And as a result of this second complaint to mom and her reaction to the second complaint, the victim is credible, should be believed, and the jury should find Mr. Maisonette guilty. So without that second complaint to mom, there is no argument by the Commonwealth that the victim should be believed because of the second complaint. So while the testimony itself may have been fleeting, it was not used. It was exploited very adeptly by the Commonwealth.
On the question of trial counsel's ineffectiveness, calling mother as a witness, are we looking at that in the moment that he's making the decision and what he anticipates, or she anticipates, excuse me, eliciting, or do we look at what actually came out?
Well, in order to determine whether counsel was ineffective, we have to look at his decision-making process. So we look at the decision. He was in front of the judge. The Commonwealth said on the record, I object to the mother being called because her testimony is irrelevant. She's not an eyewitness in any sense in this case. She's not a first complaint witness. So the Commonwealth objects. And then the Commonwealth warns defense counsel right on the record, right in front of the judge, if you call mother, you're going to open the door and we're going to exploit this. And how did counsel not foresee this going sideways like this? We've got a mother who's obviously protective of her daughter, who kicked him out of the house, and he's calling her to the stand to elicit some minor inconsistencies, maybe, not knowing how
the problem, Mr. Gauthier, is your procedural posture. You say in your brief that it wasn't a matter of strategy, but you didn't file a motion for new trial. We don't have an affidavit from trial counsel. And we don't have findings from the judge who's in the best position to make a decision on whether this would have affected the verdict at all. Instead, we have speculation.
I think, I mean, it's impossible to know from any vantage point, either the trial judge or now, what exactly the effect would have had. What would have happened if you excised mother's testimony from this case?
So my point is the Zinsser line of cases. This panel is not in the same position as the trial judge. We have no idea what counsel was thinking when he did that.
I think it's
or
pretty
or if counsel had addressed the issue with his client.
I think the Commonwealth and I would agree that by calling the mother to the stand, it's pretty clear what his objective was. His objective was to obtain confirmation of a handful of inconsistencies. The Commonwealth cites in his brief, this is what the defense counsel was doing. And I think it's pretty clear what defense counsel was doing.
But a failed strategy is not necessarily manifestly unreasonable. And without context from the lawyer and from the trial judge, I don't see how this is indisputably on the record.
It appears as if my time has come to an end. So if there are no further questions, I would rest on my brief.
I'll check with the panel. I see no further questions from either judge. So thank you very much, Attorney Gauthier. And we'll turn now to Assistant District Attorney Kidd.
Yes, good morning, Your Honors. Again, my name is Rob Kidd. I represent the Commonwealth, the Bristol County DA in this case. Turning to the ineffective assistance of counsel argument first, because that was dealt with a fair amount. As the court knows, this was a strategic decision, and the case law talks about calling a witness in itself is a strategic decision. And
the purpose of the defendant calling the mother was what, from your perspective?
The purpose of calling the mother was to bring out certain inconsistencies in the testimony, and to highlight the fact that the offense was not reported for some number of years. So I think in the closing argument, counsel hammered that home and said he used the phrase 2013, 2014, 2015, was never reported. Mother was a cumulative witness of some other witnesses, but it had some value, I argue, in hammering the point home. Counsel also expected, as the court pointed out, an inconsistency to arise between the pretrial hearing testimony and the testimony at trial. Counsel clearly had the transcript of the pretrial testimony in front of him. It may be, in hindsight, viewed as a risky strategy by appellate counsel, but we have to look at this, as the court said, as counsel at the time. I don't know. Remember, the defense attorney here, by the way, he knew the mother didn't show up for the pretrial hearing and had to be dragged in. So, you know, the defensive counsel very well may have been taking a shot, thinking that maybe mother's having second thoughts. Maybe this didn't happen. It could be that
you have on this point in terms of the strategic decision not panning out, the Kolanova case, if I'm pronouncing that correctly, the 2015 SJC case. Is that your strongest case?
I think so. Yes. So again, as the court pointed out, you know, these motions, ineffective assistance of counsel claims without the affidavit from counsel or without any input from trial counsel are looked at with, you know, some I don't know if the word skepticism, but are challenging for the defendant because, you know, hindsight is 20/20, and we don't have the defense attorney to tell the court what he was thinking when he did this. I would suggest under the circumstances, his strategy was reasonable at the time that he decided to implement it. So that would be my argument on the ineffective assistance of counsel. And if there are any questions about that, I'll just.
Can we move to the uncharged conduct?
Sure.
Two questions. What did the jury have before it in terms of a timeline for that incident? And secondly, what are the reasons that you say that was admissible?
Okay. It's apparent from the transcript reading it, and I read it last night, that the prosecutor was painfully trying to elicit from his young victim the timeline and how recent it happened before the 2016 incident, the uncharged conduct. And it seemed like he was unsuccessful in doing that. Although he did talk about the victim living in a certain house at the time that this happened, giving some time frame to it. I can't, you know, exactly pinpoint what that time frame would be. And I'm sorry, Justice Blake, what was the second part of the question?
What is the reason that this evidence comes in this case?
Okay. Well, I would suggest this does go to the defendant's proclivity to commit the crime. They're saying that the defendant says it never happened. I didn't do it. She's lying. This does show an intent, that he has that specific intent. As Justice Meade pointed out, at the time that he committed this prior bad act, he has his hand on her thigh. He's rubbing her thigh, and he says he likes it. It also has some value as modus operandi evidence in the broad sense that in that particular case, he's got his hand on his thigh near her vagina, and in the other two cases, he does touch her in the vagina. He's not touching her in the chest. He's not touching her in the buttocks. It's in that area. That's some value of that. But there's a line of cases that talks about intent and the exceptions to the prior bad act rule. So that's my argument there.
Does the time frame matter? In other words, if it was before the charge conduct of 2012 or after, does that affect the analysis?
In this case, clearly it is before. I think that the evidence shows that it's before, but I don't think
2012 incident.
Yeah, it's before the 2016 incident, I believe. At least, because that's the way the prosecutor framed the questions to his victims. Do you recall sometime before the 2016 that such and such happened? So I don't think it matters, though. I don't think the case law. I think it talks about an intent. Whether if he had the intent before, he would have had it afterwards, and it would be an act after the fact would indicate he had the intent before the fact. That would be my logical argument. Okay, so with that, I will turn to the closing argument portion of the brief, the defendant's brief, unless the court wants me to address something else. Okay.
Go ahead.
Yes, if I may have a minute, Your Honors.
Sure.
I'm just trying to get to the page here where it's on my brief. For the court's reference, the closing argument portions are reprinted on 21 and 22 of my brief. The court wants to look at them. Or those are the portions that the defendant selected. So first of all, yes, I would suggest, counsel has already conceded apparently that we're looking at whether or not this argument, if there was error in the argument, resulted in a substantial risk of a miscarriage of justice. To the extent that there were some statements made by the prosecutor that from which a jury would infer that he's saying that mother believed her daughter. I would take issue with counsel saying that the prosecutor argued second complaint, though, in his closing argument. He didn't specifically say that the daughter, the victim, made a second complaint to mother. He never said that victim went to mother and told mother. What he did say is that mother was very upset when she heard these allegations, that she kicked the father out of the house and so forth. I would suggest, as I did in my brief, that we are talking about a jury that, first of all, knows that mother is not a witness to this. The jury has heard the evidence. Mother is actually an after-the-fact witness to this. They know that, and these jurors are, presumed to have some level of sophistication about these things. Jurors, I would suggest, would know that the natural inclination of any mother, in this case, would be probably to believe the daughter, would be to kick the person out of the house.
You say that on a number of occasions in your brief, and the cases that you cite really are about jury sophistication. Do we have any cases in our court or the SJC that say that a parent is likely to believe a child and therefore it's permissible?
Yes, Your Honor. If Your Honor's look at the attachment to my case, to the
128.
Yeah, the 128 decision, Commonwealth versus DeLong, says exactly that. It says that a mother would be inclined to believe her daughter in allegations of sexual abuse. So I referred to that case a number of times.
Anything published that you know of?
No.
Okay.
So we look at that. We look at the level of juror sophistication, and then we have to look at the context of the closing argument in the context of the entire case. We have a case here I would respectfully suggest that is fairly strong for the Commonwealth. We're never really going to have an eyewitness to this type of offense, as the court knows, or very rarely going to have an eyewitness to this. It almost always comes down to credibility. But you do have a victim who promptly reports this to her mother, goes to her mother's room and says this right after the incident. You have a fresh complaint witness who corroborates that fact, that the fresh complaint, promptly reports this to her sister, the first complaint witness. And the sister corroborates that fact, that it said. The sister tells the jury that the victim is crying, she's upset, she's emotional, also consistent with being abused. The prosecutor correctly points out in his argument, and permissibly points out in his argument that these two young girls are hiding in their room while the parents are yelling. That's evidence that that the victim was upset and afraid of this man, that something happened here. There's also some details in the victim's testimony that speak of the truth. The victim is able to recount in detail the incident, that the abuser, her stepfather, was drunk at the time, that he was swoozy, I think was the word that she used. She described how he was kneeling down when this happened, specific body positions. Even with respect to the 2012 incident, she gave some fairly detailed testimony, I think, about what her father was wearing, talked about a navy blue shirt with some smudges on it from work or something of that order. So in the scheme of things, I would suggest this was a relatively strong case for the government, and reviewing that in conjunction with the law about closing arguments, and the fact that the judge did instruct the jury right after closing arguments that closing arguments are not evidence, that he asked the jury not to be swayed by sympathy or emotion and so forth.
Can
given
I ask
that,
you this, Mr. Kidd, you say in your brief, and I'm agreeing with Mr. Goth here, that the argument relating to the defendant being kicked out of the house can only be understood, or can be understood, excuse me, to a request for the jury to believe the victim because the mother believed her. But when you read the Commonwealth's closing argument, there's no such request. In fact, even the part you quote in your brief, he goes through the circumstances of what happened, the emotional, the yelling, the kicking out, and this is all in response to the defendant saying that she was lying. That he goes through the circumstances of what happened, and having to be arrested to be brought in here, and she's trying to protect her daughter. But he never says or even implies, tell me where, if I'm wrong, because I don't see in there where there's an implication that you have to believe the victim because her mother did. And we'll go back even farther. If the jury was to understand that, why didn't counsel understand that and make an objection along those lines?
He never specific. I agree with, well, yes, it's true that there's never any explicit statement there's never an explicit statement by the prosecutor that you should believe the victim because mother believed her. I guess the closest he comes is he uses the phrase kicked out over a lie. I think that's the phrase that I looked at that might have told the jury that, why would mom kick the victim out if she didn't believe what the victim was saying. But there's no indication, there's no direct evidence that the victim told the mother of the complaint. I know there's, well, anyway, I'll stop there. I don't know if I answered the question very well.
No, you did. That helps me understand it better.
Okay, all right. I don't know that I have anything more. I think for the rest, as far as the rest of it goes, it's in my brief, and I will stand or sit or whatever I do on my brief. I'll rest on my brief, I guess.
You rest, that's correct. That's the proper
what I do.
term.
Yes.
Even remotely, you rest on your brief.
I'll
check to see if Justice Blake or Justice Meade have any additional questions, and I see none. So thank you both very much for your arguments and your briefs. We'll take the case under advisement.
Thank you.
And APC versus Thomas Clarke, case number 2020-0170. Let me now introduce the panel to you today. I'm joined by Justice William Meade and Justice Amy Blake, and my name is Ariane Vuono. I don't think I need to remind you that you each have 15 minutes to present your argument and that there is no rebuttal in the appeals court. That is the appeals court in Massachusetts. I also wanted to tell you that if we should experience any technical difficulties, we ask you to be patient with us, and we will be patient with you. Someone will contact you if anything happens and indicate how we will proceed. With that said, we'll start our arguments. And Attorney Shapiro, you represent Mr. Clarke. You go first.
Thank you very much, Your Honor. Jordan Shapiro representing Mr. Clarke. This is a case dealing with the effect of a homestead on a post-judgment levy. We say the creditor cannot do anything to place any type of lien on property protected by a homestead. There's no dispute that the equity in this property is about $250,000.
Now, could you back me up there? When you say there's no dispute, where is that in the record? The value of the property?
It's in the appendix, Your Honor, where we indicate that he purchased it for, I think, $370,000. That he has a mortgage of $99,000, and so that leaves you with a $250,000 approximately as the value of the property. And I don't think.
Okay, but there's no current appraisal or anything like that. Is that correct?
There is nothing like that. That's correct. And we also attached the assessed value by the city of by the city.
Oh, okay, I'll look at that. I can see
they're
that.
all
Okay,
in
thank
there.
you very much.
Yeah, that's all attached to the motion. Thank you. And so again, we think that the Judge Cowan, when she wrote a decision, based upon three criteria that were all wrong. The judge basically was relying upon, first, she was concerned with the ability to collect. Secondly, she was concerned with protecting the creditor. And third, she was concerned with not interfering with the protection of the statute, which we've interpreted to mean affecting the use and possession by the defendant. And we say all of those criteria.
But why would it be that no part, that the entire home is protected by the Homestead Act? It's only supposed to protect the first $500,000, correct?
That is correct, Your Honor. And there's no doubt that in this case that it's not near the 500,000. If it were,
hypothetically, if it would, okay, so you would agree then, hypothetically, if the property was assessed at $1 million, that then there would be no problem in attaching the property in the manner that's happened here?
Correct, Your Honor. Correct. I would agree with that. If there's excess value over the $500,000, then it's certainly they can put a lien on it. They'd have to apply.
Let's work that out to its natural end, because it seems to me that if we were to say that, that would have to be specific to this case, because how do we announce a rule or a holding that requires a calculation to be done when we all know that people often disagree about the value of real estate? I'm worried about the rabbit hole that would take us down if we tie this decision to the equity in a particular property vis-a-vis the amount of the execution.
I don't think so, Your Honor, and that is because in presenting the motion, Your Honor, the creditor has a the defendant has a duty to present evidence as to what the value is. If Mr. Eisenberg's client objected to that and presented evidence to say it's disputed, then that would be a matter for either evidence, again, appraisals, documents to be presented to handle that dispute. And that would certainly be a concern that would be handled by evidentiary hearing. And so I don't think that's a concern for the court at all, because again, in this particular case, there's only $250,000. If it's disputed, well, why not? Sure, there's got to be evidence.
Why not make life much easier? And that is that anything beyond the first $500,000, if there is equity, is subject to a lien by the creditor. And then the creditor would then have to establish that there's sufficient equity to collect at the time that the homestead lapses.
I would,
in other words,
I would love to have that decision and reverse this judge's decision that for a $250,000 equity, they have allowed to have a lien. You'd only be allowed to have a lien if you apply. In other words, if Mr. Eisenberg's original attachment said, I'm only attaching the excess over the $500,000 equity, which he didn't do, that would have been a different case for you to handle today. But the one before you today has no dispute that it's not worth more in equity than $500,000. It's $250,000. And so there's no dispute about the values in this particular case. And I think that you're going to, again, there is a case, I can't remember the name off the top of my head, but in the papers where a judge said, hey, you got $450 equity right now. I'm allowing you to attach is to protect the creditor when it gets to be over the $500,000. And I'd have no problem with that. But where it's so far away from that, in this case, that shouldn't be a concern to this court in dealing with this case.
And well, what's the problem? You indicate that there's what the result is that it just becomes an encumbrance on the property. How so?
The lien done by the creditor in this case, it's a lien on the property. And so it is not a possessory lien, and that's one of the errors in the court's decision, that she seemed to be concerned with the use and possession of the property.
Well, we would be with you. Let's move on. How does that amount to an encumbrance on the property? If it was perfectly okay to have a lien of this nature, if the property had more equity, it would have to be the same. There would be an encumbrance then in that scenario as well.
The legislature doesn't protect. The legislature protects the first $500,000 from a debtor having to go to the lender, the creditor, and say, please release my lien. It doesn't want the debtor to be involved with anything to do with tracking down somebody who has placed a lien on the first $500,000. The legislature wants to protect the first $500,000. Debtors should not have any reason to contact a creditor under this statute. The BAER and the Supreme Court said the law is there to protect debtors. And so there's no reason to be protecting the creditor or worrying about the creditor if it's under $500,000. It prevents a refinance, prevents a sale, prevents the debtor doing anything.
Well, that's my question. That's my question. Could you just hold on a second? That's exactly my question. Can you explain to me how it is that this would prevent, if this is a lien that can only be satisfied by equity that exceeds $500,000, or if the homestead lapses, right, one way or the other, then how does that prevent the refinancing and the selling, et cetera? How does that prevent that?
All right, well, okay, so I'll go through. So when the creditor gets a judgment, then they record something at the registry of deeds that says they have a lien on the property. They have it's a levy, it's called, not an attachment. And again, attachments don't affect the use and possession, and the levy, we agree, doesn't, and a suspend doesn't affect the use and possession. But it's a document that's at the registry. So if the defendant wants to go sell his house, he has to call up or get a lawyer to call up and say, dear creditor, please release the document that is recorded at the registry that is a lien on my property. A levy is a seizure. What the sheriff does is they go to the person's home and they do what was created hundreds of years ago. They take a piece of grass off of his property and seize the property by the levy. It seizes the property. That's the initiation that causes the world to know that this person cannot dispose of his property without permission of the creditor. And that is exactly what the homestead wants to avoid. It doesn't want a debtor to have to deal with abusive debt collectors.
Now, where does it say that? Where does it say that in the homestead statute? Because I read the statute as protecting the homeowner and his or her family, but not that it protects him or her, the homeowner, from anything beyond that.
Oh, it protects the Dwyer.
It doesn't say, and we're going to let you refinance, and we're going to let you do anything you want to do with your home because you have the Homestead Act. All it is intended to do, and to be construed liberally, I understand that. All it's intended to do is to protect the homeowner and his or her family from losing possession of the house during the time that the homestead statute is in place. Where in the statute does it give you more than that?
Well, again, the statute says the law prohibits the use of recording and execution on the judgment. If it protects you from having a lien recorded on your property, then the logical result of not having a lien is that you have no reason to contact the creditor. It's designed to protect the debtor from having to deal I heard what you said. And so you say the law doesn't specifically say that he shouldn't have to call a creditor to get a release of the lien. No, the law says you can't put a lien on the property. There's no reason that the law allows this creditor to force the debtor to contact him to get and beg and plead and have to do something to cause a release of something that should have been recorded in the first place.
So that if a title examiner is doing a run on this property, they come upon a suspended levy, and that would be a full stop, right, for the title examiner?
Exactly.
Okay, does it matter if it's registered or recorded land?
Not at all.
And I know that you have both not cited to any Massachusetts case directly on point, because presumably there is none. Are you aware of any other jurisdictions that have addressed?
I'm sorry, you froze, Your Honor. Could you repeat what you just said?
Sure. Are you aware of any other jurisdictions? Because there are no cases in Massachusetts on this point.
I'm sorry, I wasn't sure what point you were
on. Are you aware of
froze.
any other jurisdictions that address the issue of a suspended levy and how that relates to the homestead statute?
I believe I can deal with that, but again, I had concluded because in Massachusetts, there is no permission to seize and there's no permission to record an execution. If you can't record either of those, then there's no concern about a suspending because you can't record it in the first place.
All right. Are you aware of any other?
That I could find that.
Are you aware of any other courts that have adopted the position that Justice Cowan adopted in the Superior Court?
I'm not.
Okay.
I'm not aware of any other court that said this in Massachusetts or anywhere else in the world, because I think she was just in error. That you can't consider the things that she considered to protect. She's protecting the creditor by allowing a lien on a debtor's property that is protected from liens. That's what.
Have you had the chance to review the amicus brief filed in this case?
I certainly did. It's the most preposterous thing I ever saw.
Well, that's not what I asked, though. My question is,
I did.
Is there a difference in your mind between the homestead estate and the reversionary estate?
Yes, a reversionary estate in all of the cases they cited deals with a foreclosure of a mortgage where a owner has a right to redeem after foreclosure. That has nothing to do with homestead law.
And again, to adopt your point of view in this case would require in each instance a determination of the equity in the property and the relationship of that equity to the judgment.
Yes, and usually done by affidavit of the defendant, and then if the plaintiff contests it, I've had hearings and trials on the values and those
I've
things.
seen the tax assessment is in the record. I've also seen the Zillow or Zestimate, whatever they call those.
Yes.
And so is it then the burden on, for example, Mr. Eisenberg's client to periodically have the house appraised for purposes of determining whether or not the value is more or less than the judgment and the homestead protection?
Sure, and these days it's very simple to do.
And does that require the homeowner to then cooperate to allow his appraiser into the property in order to make a proper valuation?
Most appraisals are done drive-by. In my experience, I do a lot of foreclosures. The lenders just drive by. They can tell by looking at the outside of the house whether it's in a range of $500,000 or less by looking at it. And so these things are all electronic, the appraisers, internet, Zoom, like you just said, Zillows, things like that. It's not a burden. The legislature wasn't worried about the creditor having to figure out how much it's worth. The facts are going to be decided by a court and evidence if it's disputed. So that's not a big deal to me.
But what about this, Attorney Shapiro? So in other words, in to follow your scenario, the creditor would have to keep his or her eyes on the property to determine when the homestead lapsed, whether the individual passed away, or sold the house or whatever. Why should the creditor have to have? Why should that burden be on the creditor? I mean, the creditor has a valid judgment for a sum of money. And here, your client, no other way to satisfy that is to put a lien on the property. So why would the creditor have to be constantly following that?
The reason for that is that the legislature has protected the debtor by the homestead law. And the burden is on the creditor to occasionally, if they want to, or whenever they want to, be able to determine the value. And I would suggest that if the creditor moved to get permission to enter, they could.
It's more than just determining the value. They're going to have to determine exactly that, if the property has been sold, or if the homeowner has passed away, or the few other manners in which the homestead statute can lapse.
But the law, it doesn't care about that. The
law does care about having a valid judgment, to validate that, right?
But this law makes that debt uncollectible if the house is not worth more than $500,000. So they can't collect that debt because it's not a problem for the debtor.
They can collect it when the homeowner passes away. So if
not really, no, that's definitely wrong. My brother was incorrect in that, Your Honor.
Okay.
And what happens is when the debtor dies, the homestead remains to protect the family that lives there. And when the debtor dies, that lien dies with him, and the creditor has to go to the probate court to get permission to get at that asset. And so that was a mistake by my brother. I suggest to you respectfully.
All right.
And just like it, that is not a fact of this case, though. That's not an issue for this court.
Thank you. Thank you for clearing that up. I appreciate that. Thank you for clearing up that point. Excuse me. Your time is up. So just one moment. Your time is up. I'm going to ask the panel if they have any additional questions for you. Attorney Blake, Attorney Meade, I don't see any. Okay. So thank you very much. And you can be assured that the other arguments you made in your brief will not be overlooked. Okay.
Thank you very much, Ron. Thank you, the panel.
Yeah. All right, Attorney Eisenberg. You're on mute, sir. You need to unmute yourself.
Thank you, Your Honor. May it please the court. My name is David Eisenberg, and I represent the appellee, HARTOG, BAER, and HAND. HARTOG, BAER is a law firm in California, and they're holding a judgment against Thomas Clarke. They domesticated the judgment here in Massachusetts and obtained a judgment. Post-judgment, they levied and suspended on Mr. Clarke's property. Mr. Clarke objected based on the homestead, and the Superior Court allowed the lien to remain on the property. Mr. Clarke appealed.
What was the authority of the Superior Court to allow a suspended levy?
The authority of the Superior Court, Your Honor, I would suggest dates back to the 1860s. And the issue here is whether the estate of homestead is a fee, as Mr. Shapiro argues, or whether it's an independent interest from the fee. And back in the 1860s, the case of Smith v. Potvin established that the homestead is not a fee simple. The case says that the homestead right is not a fee simple estate in the premises set off as a homestead. It is only an estate in the premises to be held while the husband is a householder. It is precisely this limited estate which was exempted as a homestead. Therefore, the homestead, which is a temporary interest or a present interest in the property, is limited. It's not the fee itself. And as the amicus eloquently points out, there is a reversionary interest. There's another interest in the land other than the homestead when the homestead is created. And it is that reversionary interest or remainder in the property which is attached in this case. That's what the post-judgment lien attaches to. And there are other cases from the 1860s cited as well. White v. Rice. What exists beyond the homestead is subject to attachment. That is exactly what's attached in this case. What exists beyond the homestead, that future interest.
Well, let me ask you this. It seems to me that Attorney Shapiro does not disagree with you that he says that if the value exceeded $1 million, that then the lien would attach to that second $500,000, right? But he's saying that that can't be the case here because it's undisputed that the value of the property is well below the amount that's protected by the homestead.
Well, I have two responses to that, Your Honor. One is that Mr. Shapiro relies on the plain language of the statute. There's nothing in the plain language of statute that provides this demarcation that says you can only get an attachment or you can only get a post-judgment lien or levy if the value is greater than $500,000. or it doesn't say you can't get it if it's less than 500,000. There's nothing in the statute that has that demarcation. In addition, there's nothing in the statute that indicates that somebody has to do this appraisal analysis in order to maintain an attachment or to maintain a post-judgment lien. In addition, I would point the court to Chapter 236, Section 18, which addresses the issue of an execution upon property in which the homestead exists. That particular statute sets sort of an entire procedure. If the creditor, in this case, HARTOG BAER, goes to liquidate the property, then Section 18 tells the sheriff that they then, at that time, need to do some appraisal and determine the value. The attachment is already on the property. It's only when the creditor goes to liquidate the property is it important to know what the actual value of that property is and what the equity, and whether at that time the homestead estate covers the entire value of the property. It's not before that. And in this particular case, the only thing that HARTOG BAER is doing is preserving its position in line. It's a creditor of Mr. Clarke. What Mr. Shapiro is suggesting is that because there's some equity in the property right now, that Mr. Clarke could go out there and refinance or remortgage and favor another creditor over HARTOG BAER. The law doesn't allow Mr. Clarke to do that. Mr. Clarke has the right to possession of the property. His heirs have, his offspring under the homestead statute have a right to possession of the property, but there's an interest beyond that homestead when they no longer have possession of that property.
That doesn't make complete sense to me, because Mr. Clarke could determine that he needs to refi because the mortgage rates are so great right now, and that would benefit his family, and having a suspended levy would preclude him from doing that. You would have to sign off on it. That doesn't seem to be consistent with the purpose and intent of the homestead statute.
Well, I would disagree with Your Honor. I think he's allowed to live in the house. He's allowed to have possession of the house, and we're not doing anything to oust him from possession.
But if he went to refi, you would agree with Mr. Shapiro that there would be a hard stop on the title examiner once they discovered a suspended levy.
I don't know that I'd agree that he could refinance the house and increase the amount of debt on the house while our lien is there. If he wants to refinance
What
the
if
house—
he wants to refinance from 5% to 2%? Doesn't take out any equity. He has to get your client's permission to do that.
That's correct. He would have to get my client's permission to do that. And
isn't that contra to the purpose of the homestead statute?
I don't think it is, Your Honor, because I think the homestead statute protects his right to live in the home. He still has the right to live in the home. He doesn't have a right.
Doesn't it protect his equity up to $500,000?
It protects his equity up to $500,000 in certain circumstances. The cases that Mr. Shapiro cites are all bankruptcy cases where there are Chapter 7s, there are liquidations. So at that point, you're talking about a liquidation, the same thing that Section 18 is talking about when the creditor goes to liquidate the property. None of those cases say that the debtor has a right to refinance and take advantage of a better rate, or that the debtor has a right to take out more equity in the property over and above the lien that is already on the property, that's properly on the property. We're a creditor. We've established our rights. We got a judgment in Massachusetts. We've recorded our lien. So we're in the position we're in. And Mr. Clarke doesn't have a right to then favor some other creditor and do something else to change the position that we've established. And the homestead statute doesn't suggest otherwise. The homestead statute is limited to that interest. It's limited to the current possessory interest in the property and his right to live there. It doesn't attach this future interest, which is what we're preserving at this particular time. If the homestead is no longer valid on the property, if Mr. Clarke dies, if Mr. Clarke moves, if Mr. Clarke sells his home and doesn't use the proceeds for an additional property. But again, we're not there at this point. We're just talking about maintaining the lien that is currently on the property. And it's a lien on the property. It's not a lien on the homestead estate. The lien that was issued in this case is specifically expressly subject to the homestead exemption. So everyone can see that when the sheriff levied and suspended, the sheriff said it's subject to the homestead. And
so let me ask you this then, if it's subject, if that's so clear, And back to Justice Blake's question about whether or not a title examiner, if they saw this suspended levy, would certainly come to a hard stop, full stop. Why would that be the case? In other words, if the lien is so clear that the homeowner is protected under the homestead statute by the first 500,000, how does that amount to an encumbrance?
I'm sorry, I don't understand your question, Your Honor.
Okay, I'll try. I guess I'll try.
No, I apologize.
No apology necessary. I feel like I'm back in property 101 a little bit. The question has been posed as to whether or not the lien, the suspended levy poses an encumbrance on the property, such that it would prevent the homeowner from refinancing the property, right?
And I think that it would.
Okay.
I think it is an encumbrance on the property.
Okay. Such that you've agreed that you would have to, that the homeowner would have to seek your permission, or the permission of the lien holder in order to refinance, correct?
Correct.
So when you say that in this case, however, it's clear, it would be clear to anybody looking at the property and doing a title search that the homestead is protected. This is subject to the homestead. I'm not understanding why then you take the position that your suspended levy would be an encumbrance.
It's an encumbrance on the property, Your Honor. It's not an encumbrance on the homestead. As I started out, the case of Smith v. Potvin established is that the homestead is a particular interest. It's part of the fee, but it's not the fee. The encumbrance is on the fee. And the encumbrance is on what remains after the homestead. So he has the right to live there. If he files for bankruptcy, the bankruptcy court would deal with it as they did in Dwyer and the other cases cited by Mr. Shapiro in terms of a liquidation, and he would get that money from the property despite our lien because he has the homestead. But that's in a liquidation scenario, which we're not in right now. We're just talking about putting an encumbrance on the property, which is a valid encumbrance under the statutes. And nothing about the homestead statute prevents an encumbrance of the type that we're putting on, which is the interest beyond the homestead that exists with every property. As the amicus points out, when the homestead is created, the present interest in the homestead, there's also a future interest that is also immediately created, which is that interest that applies when the homestead ends. And that's what we have the lien on right now. So we're not interfering with Mr. Clark's right of homestead. We're not interfering with his right to live there. We're just preserving our position on the property. And the statutes and the case law, as far back as the 1860s, establishes that this type of lien is appropriate and this type of lien may be maintained on the property.
Mr.
I hope that
Eisenberg,
answers your question.
I have the concern that I expressed to Mr. Shapiro about what our holding is in this particular case, and then what it is for the legal community at large, because you make a point at footnote 5 of your brief to talk about the fact that your client is a law firm, they understand the law, they know what their obligations are, they're not going to do anything they're not supposed to do. But if we adopt your proposed holding in this case, there are plenty of non-sophisticated, non-lawyer people in the same position as your firm that have judgments. And I think about all sorts of landlord-tenant issues, I think about divorce issues, and they don't have the sophistication that your client as a law firm has. And I worry about what the impact of this holding would be to the greater bar. Could you address that?
Yes, well, I think the beauty of what we're asking for, Your Honor, is that it is the type ruling that would apply across the board. It's not limited to whatever the equity is in the property or the value of the property. It would allow creditors, and this has been going on in the courts of Massachusetts for as long as I've been practicing, where creditors go in there and they don't focus on the value of the property, but they want to lien on the person's home, and the Superior Court judges routinely allow those liens. In this particular case, we have the lien, and while my client is sophisticated, if my client weren't sophisticated and they did go to liquidate, the burden would be on the debtor at that time to hire a lawyer such as Mr. Shapiro, who would go in there. This happens every day when people are sued or when something's happening adverse to them. They hire a lawyer, they go into court themselves, and if they go into court pro se, the judge, in my experience, would suggest that they'd be better served by finding an attorney because it's difficult to defend yourself. And if they do find an attorney, it would be up to the attorney to follow the law and say, no, creditor, you can't liquidate this lien right now because the value is less than $500,000, and we're entitled to, as a homestead, that value of $500,000. And in addition, as I said, in Section 18, it specifically, 236 Section 18 specifically instructs the sheriff what the sheriff needs to do. If the judgment of he's supposed to obtain an appraiser, and if in the judgment of the appraisers the premises are of greater value than the amount of either the automatic homestead exemption or the declared homestead exemption as applicable, the appraisers can do something. Well, the contrary is also true. If the value is less than that, then the sheriff is instructed they can't do anything.
So you said that this happens routinely in court. Are you aware of any reported or unreported cases that adopt the holding that you're suggesting here, or even of any Superior Court decisions which are something more than a margin note, which we have here?
I'm not aware of any reported decision where we're talking about a post-judgment lien and a debtor coming in and saying that the value of their property is less than the amount of the homestead, and therefore you cannot maintain a post-judgment lien. I'm not
What
aware
about
of any
unreported?
I'm not aware of any reported or unreported case.
And what about
but
outside of Massachusetts? Sorry, Judge Vuono. Outside of Massachusetts, anything?
I'm not aware of anything. I didn't research it outside of Massachusetts, but also, again, going back to Mr. Shapiro's argument that he's basing it on the plain language of the statute. As I said, there's nothing in the plain language of the statute that would prohibit a creditor from placing.
But there's also nothing in the plain language of the statutes where he points out that talks about a suspended levy. It strikes me as a bit odd, and this is such a routine matter, that there's nothing on this for 100. I mean, the homestead statute has been around for centuries, a century anyway. How could it be that if this is so routine that we don't have anything, no court has spoken to it?
Well, that's why I would direct the court to the cases that are cited by the amicus, some of which are cited by us from the 1860s, that I do believe, and I think when the court reviews those more closely, the court will see that they do address this issue.
Well, as a lawyer, is this routinely happening in the Commonwealth? Is it every registry of deeds and throughout the Commonwealth? Are these suspended levies present?
Yes, they're routinely on properties where the sheriffs go out there and levy and suspend on properties. It happens all the time in my experience, and I think any title examiner would be able to report that is their experience as well, that they see a lot of levies and suspensions on properties. And it's not just because there's a homestead. The creditor could have any number of reasons for levying, suspending. Maybe they don't want to go through the process of liquidating it because there are issues with liquidating properties and having to wait a certain period of time, but they're routinely throughout the registries in the Commonwealth.
Okay, well, I appreciate the answer. I appreciate, I think I could read your objection by the look on your face.
No,
there.
it's
so
just the 2011
there is no
statute,
rebuttal. There is no rebuttal in our courtroom. Thank you for answering that question. Thank you as well, Attorney Shapiro, for answering your questions. I'm just going to check as your time is up if Justice Meade and Justice Blake want to follow up with anything. I see that they don't. Okay. Well, this is a very interesting case. Thank you for your briefs. We also thank Nelt for the amicus brief, and we'll take the case under advisement. Again, answer back to you as soon as we can.
We're live.
Okay, thank you very much, and good morning to all of you. Thank you for being on the waiting room in a timely manner. We're taking this case out of order because you're all here. So I'll call the case Department of Children and Families versus another father, the second. And the case number is 2020-0036. I'm joined today on this panel by Justice William Meade and Justice Amy Blake. I understand, Ms. Cummings, of course, you have your full 15 minutes to argue on behalf of your client. And with respect to the lawyers for the child and for the department, I understand that you're splitting your time evenly. Is that correct?
Yes, Your Honor.
Okay. I will remind you, of course, that this is being publicly broadcast, so to speak. It's on a YouTube channel, and so the case is impounded, and please avoid using any names as a result. Sometimes during the course of the argument, we have some technical difficulties, and if we do, we'll be patient with you. We hope you're patient with us, and someone will get to you as soon as possible should something happen, all right? So with that said, Ms. Cummings, Attorney Cummings, would you please begin your argument?
Good morning. May it please the court, Brianna Cummings for the appellant father. Father is on appeal before you today because he wants a chance to present evidence on his mother, whom he has been trying to put forth as a competing plan since the day his child was removed 7 years ago. I don't think anybody here disputes that a parent in father's situation whose child is in state custody and whose parental rights are on the line has a right to a hearing on his competing plan. I don't think anybody here disputes that father did not get such a hearing in this case. What we saw instead was father repeatedly trying to present his mother to the court and being quashed for procedural reasons. And the judge, who was on notice that he was trying to present this plan, didn't make any effort to help him make his case. Appellees will argue that the absence of a competing plans hearing in this case is okay because father chose to go pro se, or because he somehow should have been a more sophisticated litigant by the second trial, or a variety of reasons along those lines. But none of these facts justifies foregoing a hearing on father's plan with the judge making a decision about the best interest of this child without hearing all of the available evidence, or the judge putting the child up for adoption with strangers without hearing from the blood relative who has been clamoring at the gates since this case began, or and nothing father did or didn't do in this case justifies the state's termination of his parental rights without a competing plans hearing. And I have 4 basic reasons for that. First, the best interests of the child. The best interests of the child are best known when the finder of fact has before him all the available evidence, not just one party's evidence. That's why every party in these proceedings has a right to a lawyer, the right to discovery, to state funds for expert witnesses, etc. We cannot sit here today, 7 years since this case began, and say with confidence that father's competing plan would not have been in this child's best interest. We don't know almost anything about the grandmother that he has been trying to put forth since the beginning.
Can I ask you, Attorney Cummings, if I could, a preliminary question is, do you agree that you have not challenged as clearly erroneous any of the 131 findings of fact?
Well, some of the, I haven't spent time in my brief on that, but you'll see that some of the findings are internally contradictory.
But you have not raised a claim on appeal that the findings of fact, any of them, are clearly erroneous.
No, I haven't built my argument on that.
Okay, so with that in mind, at page 24 of the judge's decision, starting with finding 67, he goes through a page and a half about the potential other placements. Those are my words, not his. The last one, which actually he devoted the most amount of time to, is your client's mother in Florida. So I'm trying to reconcile your argument that he was unable to present his competing plan. Perhaps it wasn't in the most artful of ways, but it seems to me by these findings that Judge Lyman certainly had that before him and made findings both about the grandmother and whether or not it would be in the child's best interest to be placed with her. So can you help me reconcile that vis-a-vis your argument that he didn't consider the plan?
Sure. You'll see in that, so in finding 67, and I think in conclusion of law 27, he gives his reasons for rejecting the grandmother. Mainly, he was concerned about the children being able to see their mother, and secondarily, that he didn't want to move them from their pre-adoptive home after so many disruptions. And he also made other findings that G did not want to live with her grandmother, but there is evidence from the first trial that she would have wanted to if she could have lived there with her sisters. Both of her parents were enthusiastic about her living there. So I guess
that's why I asked you about whether you say any of the findings are clearly erroneous, because it seems to me that one of the main concerns about Justice Lyman, outside of what the grandmother could or couldn't do for the child, was the desire of everyone to keep the three children together, and that grandmother had said she'd be unable to do that. I know she has subsequently filed an affidavit to the contrary, but at least as the time the evidence closed, that was the information Judge Lyman had. And if that finding is not clearly erroneous, I need you to help me get to where you are on this point.
Okay. So when the social worker testified that the grandmother didn't want to take the three girls, father tried to show the court a letter from his mother saying that she was interested in the three girls. And because it was hearsay, the judge excluded it. So even though based on the evidence that the judge had in front of him, his finding is not clearly erroneous, it is clearly erroneous if there had been an opportunity for father to present those facts, then it would not have been supported by the evidence. So the problem is that there wasn't due process. There wasn't an opportunity to present that to the court. And
so the statement attributed to her, again, in finding 67 to the DCF social worker, that she would, quote, hands down take Gianna, but would not take the twins as they are not her family. And, quote, they would be a lot of responsibility to take on, end quote. If that's not clearly erroneous, and I don't mean to beat a dead horse, and I apologize, but that seems to be the thrust of your argument, is that this is a competing plan case and the judge didn't consider the competing plans. And again, maybe not in the most formalistic way presented by your client. It seems to me he certainly considered it and then rejected it. So then that goes to the weight of the evidence, which is certainly within the purview of the trial court judge, no?
Yeah, I agree. He considered this plan, but he didn't have all the evidence that father wanted to present. Father didn't have a full hearing. And even if the judge was correct that this was not the best placement for the children, the judge did not consider the potential interest in this grandmother and grandchild maintaining a relationship. And effectively, these two who had a lifelong relationship suddenly lost it almost 4 years ago, not because the judge made a considered decision that she didn't have an interest in this relationship anymore, but just because it fell by the wayside, nobody really thought of it. And so that's another interest the child may have, especially because, I mean, first, she had a relationship with this grandmother, and second, even if she didn't, this grandmother she no longer has any connection at all to her African-American roots or her birth family. So there are, and the judge didn't consider any of that. He didn't make any findings about it or address it. And this, even with the evidence that the judge had, grandmother W is the only family member in this case for whom we have no evidence that she has ever harmed the child. And she is the only family member whom the state made no effort to investigate or reunify. There was no home study or anything. And allowing the state to come in and make a decision that the children should stay with this other placement rather than with their grandmother, when there's no evidence that it's necessary to protect the children from harm, is far beyond the limited role of the government that we want in these cases. When they're interfering with these families, we don't want them coming in and saying, she should live with her sister, she shouldn't live with her grandmother, unless there's need.
Okay.
So aside from the fact that maybe this would have been the placement that was in the child's best interest, especially during the first 4 years of the case when everybody agrees the children were in harmful placements. And aside from the potential interest in the child maintaining this relationship, father has a due process right to this hearing, and he didn't get it. And he didn't get it because the juvenile court is not used to pro se litigants, and the judge was annoyed with father here. As the DCF attorney said, father was in his words, wasting everybody's time. He caused him his trial. He seemed to take up a lot of time on tangents, and there was no effort to help him when he was trying to put forward the plan that everybody in the case knew he had been trying to present all along. There was no effort to help him.
I understand your ineffective claim, and putting aside that he was self-represented at the trial for a minute, would you agree with the proposition that you cannot demonstrate prong 2 on an ineffective assistance claim, that is prejudice, if there's overwhelming evidence of his unfitness? Do you agree with that legal proposition?
I agree if the issue is termination, I agree with that. But if there's an issue of the best interest and the competing plan, then even if there's overwhelming evidence the father's unfit, there's not necessarily overwhelming evidence that the right plan was chosen. Process matters. This family from the beginning, 7 years ago, for 7 years, they have been trying to get the child to this grandmother in Florida. And for 7 years, she was not heard. And if they're going to lose this child forever, it's going to make a difference if they had process or they were just shut out. And it matters that even though father had a lawyer and chose to go pro se because the lawyers had not helped him put forward his mother, he still had, it still matters to give people like him a chance to present their case. And we cannot sit here today and say with certainty that it would have been a bad thing for her to go down to Florida. It's possible that if she had gone down there 6 years ago, she would have been spared a lot of pain. And if we don't insist on following process, then the children suffer, as happened here, because there was no one to oppose DCF's placements in court.
What option did your client have? And I think he was represented by counsel at this time. When DCF determined to stop the ICPC for Florida, what could he have done?
The lawyer?
Wasn't he represented at that time?
Yes.
Okay, so what could his lawyer have done?
Either he could have asked the court to order an ICPC. In addition, or as an alternative, he could have hired an expert to do a home study so that there would be something to present to the court, some basis for the court to choose the grandmother. What happened here, there was no chance. Father didn't even have a chance. And this is a case where we don't know that that's necessarily the best outcome. Both parents were really enthusiastic about this placement. The grandmother wanted her there. The child testified that she would like to live there if she could go with her sisters. It's possible that this family could have been.
Can we consider her testimony if she didn't testify in the second trial? Mom and daughter did not testify in the second trial.
They did not, but that's.
The judge didn't use that for the basis of any of his findings, correct?
Correct. No, the judge did not consider any of that. The judge did not see any of that.
So we can't either.
Well, the argument is that he wasn't given an opportunity to present this evidence. And that goes to the prejudice that if he had been given an opportunity, if he had been given some assistance, he had standby counsel there. If the judge had said, can you help? He's trying to put on a plan. Can you help him figure out the rules of hearsay? And then the court would have had more evidence. And so that's why that's there. I'll just conclude by saying that children have a substantive interest in their relationships with extended family as with their parents. And the government should not interfere in these relationships without the requisite process and without real confidence that government intervention in these relationships is warranted. And that did not happen here.
Well, thank you very much. And you can rest on your brief for any remaining arguments that were not touched upon this morning. I'll turn now to Attorney Bayless for the Department of Children and Families.
May it please the court, Jeremy Bayless for the Department of Children and Families. It's long been established that a competent adult can elect to proceed pro se. It may not be always in their best interest, but they have that right. And Commonwealth v. Ferretta establishes that while pro se litigants are entitled to some additional care from the court in how to proceed, they are still bound by the same rules as all participants in trial. In this case, father, when he was not granted a new attorney, and the only basis he gave the court for asking for a new attorney was that he felt that his attorney did not have his heart, or I guess his best interest at heart, to paraphrase the father's argument. He elected, after a lengthy colloquy, to represent himself. He then got more opportunity to present his case than almost any other pro se litigant would. He got to go through a full trial during which he was told the procedural errors he was making. He was told that if he wanted to call the paternal grandmother as a witness, he needed to put her on a witness list and alert the court and the parties ahead of time that that was going to happen. He was told about the rules of hearsay. He was told that he needed to have an ICPC study before the court could place the child with the grandmother, and he was told that well before the trial. Father then, by virtue of his own misconduct and inability to control himself during trial, received a mistrial. After that point, father had a full year during which he had the benefit of standby counsel that he could have sought to achieve, and yet he could have sought to prepare his mother to testify.
Mr. Bayless, do you think that the father forfeited counsel or waived counsel?
I mean, I believe father waived counsel. He requested to a new counsel. He was told no, and then he had the risks of being proceeding pro se explained to him, and he expressly chose to do so after a colloquy. And so because of that, he can't now allege ineffective assistance, that he was denied the ability to present arguments that he himself chose not to present. And
do you think that Judge Lyman had, not in a formalistic way, but do you think Judge Lyman had before him evidence of father's competing plan with respect to his mom?
So that's a bit of a challenging point, because Your Honor is correct that Judge Lyman was aware that the grandmother was on the table, which is why Judge Lyman made the findings he did. And there was evidence supporting those, that the paternal grandmother had said she would take the oldest child, but not the twins. However, when father was asked at that trial what his plan was, he did not say my mother. He said his plan was to have the children live with him in one of two states. One was Florida. I don't recall the other one, but I believe it's in my brief, until his criminal record was cleared up so that he could leave the country. Whether or not that was the plan father wanted to present on the inside, that was what he told the court. And he's not entitled now on appeal to go back, take back his affirmative statement. Excuse me, I'm losing my voice. Take back that affirmative statement and argue that no, he meant to present something else. As a pro se litigant, father is still bound by his own words. This isn't a case where father was saying throughout the trial, Your Honor, I want to present my mother, but I don't know how. And everyone said, I'm sorry, you're out of luck. Instead, father had the benefit of standby counsel. Father had at least enough competence, as is demonstrated in the life of this case, in which he filed and prevailed on his motion for a late on his motions. He didn't prevail pro se, but he filed several motions with the court following the decision to challenge the court's actions, indicating that he certainly had the capacity to reach out to the court when he felt something was wrong that had happened to him. So what's happening on appeal is that father is alleging, with the benefit of both hindsight and speculation, that had his attorneys behaved differently in 2017 or earlier, he might have had the capacity or might have had the ability to present different facts at the second of two complete trials that he represented himself at, and that the facts which he had not even pursued in his representation would have not only been different, but they would have been different enough to change the outcome of those proceedings. And that's simply not true. This is particularly true since when the court was making its decision in the second trial, the goal is to look at the current circumstances of the children and with regards to placement, figure out what's in their best interest. In the
Mr.
case,
Bayless, in light of your time, you don't need to respond to this, but for myself, I want to make the observation that the way this case started out and what this child went through in the early stages of DCF's involvement is of great concern to me. Ultimately, whether or not it impacts the judgment, the decree will be for us to decide, but DCF needs to do better.
I don't disagree, Your Honor. This is certainly an example of a case where the department's position of attempting to reunite with mother was not grievously mistaken at the time, but it clearly, with the benefit of hindsight, was not the best. A lot of opportunities to improve practice, but the question before the court is Your Honor is well aware, is whether or not there was an error in the decision terminating father's rights in the second trial, years after that, where he had represented himself and he had chosen not to present evidence that he now wishes to present. And father doesn't have the opportunity to get a third bite at the apple in this case to present evidence that he had known in advance, both that there were procedures for how he was going to introduce that evidence, and simply chose not to do so. And in fact, argued against the position that he's claiming on appeal. It's difficult to understand how father can say the court erred in not giving custody for his mother when father himself asked for custody to go to him at the trial. He didn't even mention her name. And so, as my time is elapsing, I'll cede the rest to my brother and respectfully request that this court affirm the decision below.
Thank you, Attorney Bayless. I appreciate your argument. Attorney Cohen, on behalf of the children.
Please the court, Attorney David Cohen on behalf of just the one child here.
Just one.
Child. If I may, I think I'll just give a few concrete examples of what Attorney Bayless pointed to about the final year between the first trial and the second trial, because I think that just to make it concrete for the court about father's missed opportunities here, perhaps we might say, but that for which he bears responsibility, and then move backwards to father's claims of before the trial, which of course is where father wants to focus. So just a couple examples there. As Justice Blake alluded to, the child testified at the first trial, and there was testimony that father's alluding to and wants to invoke here that the child wanted to go to the paternal grandmother in Florida, and that was on the table at the first trial. But then of course father caused a mistrial, and the child did not testify at the second trial because she was no longer willing to testify. So that's evidence that the father lost in a sense because of his own actions. Father also, I'll compare father to the father of the twins in this case, the other father in this case. And immediately after the mistrial, this is just a few weeks after, on October 19th, 2017, that father went into the court and asked for and received new counsel, which is something that father here could certainly have done and did not take advantage of doing it. And the other father knew to do that. The trial court at that time says, sure, because we don't have second trial dates picked, it's actually easy to make that change. And that's volume 9, page 167 of the transcripts in the appendix. And then finally, the third point along those lines, father really, his standby counsel was still appearing on his behalf at hearings between the first trial and the second trial. But father really did not, or only did at the end, and then walked out of those, threatened to or walked out of those hearings because he didn't really think he needed to be there. Some of this is, for instance, as a particular example, volume 9, page 282. I think that was in May of 2018. I don't know the exact date, but that's where his standby counsel said, I'm here and father's not here. I can't find him in the lobby. I reached out to him. So there are examples of that on the record to which I would direct the court. Now, just moving back, as I think this court has accurately focused on, the real thrust of father's argument here takes us back 7 years to the very beginning of the case. And then a few years afterwards, still before trial, well before the first trial, where father's alleging that the performance of his prior counsel fell below that of an ordinary fallible lawyer, in particular with not advancing the paternal grandmother. And I just would say to the court that contrary to father's claims, there is evidence on this record that father's prior counsel did have a strategic reason for not pursuing the paternal grandmother at those key times. One was with the first attorney, Attorney Oliveira, where father told her about 4 years before the first trial that father's first preference was to reunify the child with mother in Massachusetts, and only if that was not possible to place the child with paternal grandmother in Florida. That's Appendix 2, page 60, paragraph 2. It's one of those affidavits. And this was a bit of an incompatibility, which is what that attorney says in her affidavit, that if father wanted child to remain wanted to be with mother was in Massachusetts, and pursuing the ICPC and pursuing paternal grandmother would potentially conflict with that. Now father's claiming on appeal that was just Attorney Oliveira's misunderstanding of his position then. She was mistaken. It's unpersuasive. Father was certainly a roundabout in his positions throughout this case, but it's unpersuasive because of two reasons. First of all, father later expressed communication with, if we're to believe it, with his second attorney, left that attorney with the same understanding of father's position. So we've got two attorneys who are saying the same thing here. That's Appendix Volume 2, page 63, paragraph 6. And also we have evidence that father also told DCF2 around that time that he wanted to work toward reunification with mother. And really that's something that father's brief concedes. Father's reply brief at page 14 cites to Volume 2, page 136. Exactly father's reason for why he told DCF he wanted to pursue reunification with mother, that he was frustrated with DCF, they didn't hear him or believe him, is not relevant to an ineffective assistance of counsel claim and what his attorneys did or didn't do. And then there's a little bit of a similar point, maybe for a different reason, about his second attorney, Attorney Karp, where father told Attorney Karp that the paternal grandmother had not renewed her request to DCF to be a placement resource. And that's Volume 2, page 64, paragraph 11. So, and this is a client that attorney could not easily reach in the 4 to 6 months really leading up to the second trial in 2017. I mean, this, according to the record evidence, anyway, prompted that attorney to file a motion to withdraw about 3 months before trial because he said he couldn't find his client. And that's at Volume 2, page 113, 17, 18, and 22. So I would just point those things out to the court, that there was a strategic reason. And then, of course, even if as Child does not concede that the performance of these attorneys did somehow fall below that of an ordinary fallible lawyer, there is, as Justice Blake mentioned, the overwhelming evidence of father's unfitness, adoption of Aziza, and I won't go over it all here, but father had did not see his child except once in his first 7 years. His criminal record is not cooperating with services with DCF, is not even telling them his address, is not coming to Massachusetts for a year and a half to 2 years into the case, or if he came once, I think in the first few months, he didn't tell DCF or necessarily his attorney. We don't know. So it's really implausible that the most zealous advocacy here would have changed this result. And of course, that's care and protection of Georgette. If the court has no questions, the Child would rest on her brief.
I see no questions. Thank you for your argument. Thank all three of you for your arguments. These cases are always very difficult. This case in particular raises very serious issues. And we'll take the case under advisement and get an answer.
We are live.
Okay, fine. Thank you very much. And good afternoon to you both. I'll call the case. It's John Doe number 137033 versus the Sex Offender Registry Board. The case number is 2019-0823. I'll remind you, of course, that the case is impounded. I'll also remind you that you each have 15 minutes to present your argument. Now we'll introduce the panel. I'm joined today by Justice William Meade and Justice Amy Blake. Thank you all for your patience. Attorney Fogarty, I know you were in and out of the waiting room a couple of times. Attorney Chanel, I know it was difficult for you to connect, but we're all here now and we're looking forward to hearing your argument. Let's just hope we don't have any other technical difficulties. Attorney Fogarty, you represent John Doe and we're ready to hear your argument.
Thank you, Your Honor. Edward Fogarty for the plaintiff in this particular action. And this action involves the finding of a level 3 against a young man who at the time of the crime, which would have been 2006, he was 19 years old, and he had a relationship with a 14-year-old. He, through the record, it's pretty well established that he suffers various mental disabilities. And I think it could be argued that he had, even though he was 19, he had the effective age of 17 or maybe even younger. But in any event, he eventually pled guilty to indecent assault and battery, served a sentence, and then was, I believe, he placed on probation, and he received sex offender training. Since that time, he was placed, of course, at a level 2, I believe, to begin with.
Originally.
Right. And then since that time, he's committed a number of antisocial acts, which would be criminal acts, but none of them are sexual in nature. And if I understand the reading of Doe 496501, first off, I think there should be a requirement that the Sex Offender Registry Board hearing officer make a clear findings pursuant to that case of the various elements involved. But secondly, I think the case makes very clear that the risk and the dangerousness that is involved in any of these cases is that of sexual recidivism or committing to commit a new sexual offense. And there is zero, let alone clear and convincing evidence that this young man would commit any type of sexual offense. The history of the case is somewhat intriguing in that in 2009, the Sex Offender Registry Board made a first attempt to find him at a level 3 and did not. And it was based primarily then, again, on non-sexual, antisocial criminal activity that he had conducted since his original sentence. That was then, they then subsequently tried again, and I think this case originated in 2016. I'm not quite sure, I can't remember the history. And the hearing officer in this case, I would argue, goes out of his way to really make findings consistent with the regulations that there is violent criminal activity. And I argue in my brief that I think there's arguments both ways as to whether these are truly violent acts. For example, he found that he made a finding that the assault and battery at the prison was a violent act. Well, of course, assault and battery is a violent act. However, it was dismissed, and the assault and battery regarding a sex offender I think recognition has to be taken that a sex offender in a prison setting is himself or herself subject to some pretty severe violence. And so
what about the armed robbery where he pointed the gun at the woman's chest to steal the Nintendo DS?
Yeah,
seems violent to me.
Yeah, no, you can't argue that that's not violent. I agree.
Oh, I misunderstood.
On the other hand,
you said there wasn't any evidence of violent offenses.
Well, the violence was pending at that time. So at the time that he makes his
pled
decision,
guilty, and you don't quibble with the hearing examiner's ability to consider it.
No, I don't. However, even at that, and I give it to you, I mean, it was violent behavior, and the reckless endangerment of a child, I argue that it could be construed as not violent, but clearly it's a crime of violence. But again,
well, of course, I don't think you can argue it isn't. He watched a woman beat a child to death, right?
I don't know if he watched him, Your Honor. I think the finding by the I think it's pretty clear that he was present in and around the household, but whether he actually watched it, I don't think we have an answer to that. The police officer.
Do you know how big the house was?
Hmm?
Do we know how big the house was?
There's no finding in the record. It's not established. But ultimately, it comes down to can there be any finding that this gentleman should be placed at a level 3 sex offender when there's just zero history of any kind of sex offense aside from the initial act, which I argue is, yes, it's a sex offense, but it's a singular offense. There's been absolutely zero likelihood of recidivism. And we have an expert testimony, which you can argue back and forth, but nonetheless, he's a qualified expert and he gives a reasoned opinion that this gentleman is not likely to recidivate, and is supported in the record.
You're talking about Dr. Brown, right?
I am.
He doesn't seem to understand that the hearing examiner can consider the non-sexual crimes that he's committed, right?
Well, I don't know if he doesn't understand it. His position is that it's irrelevant to his finding. He's making a decision.
But the cases and the statute says otherwise, right?
Well, I mean, he's not a lawyer. He's a psychologist, and he's there as a forensic psychologist to render an opinion based on substantial background that he has as to whether this gentleman is likely to recidivate as a sex offender. And I think the record supports what he says. He's not likely to recidivate.
What about the fact that while he was incarcerated, he had a number of disciplinary reports? He had a sharpened toothbrush. He had unauthorized possession of medication. He had conduct disruptions. So if you put aside the other crimes that he was arrested for after the fact, his behavior within the institution seems inconsistent with somebody who's going to play by the rules in society.
Well, I'm not trying to argue that this man is not likely to reoffend in some capacity against society. You can't make that argument. He's certainly done it any number of times, and he's got mental defects that point pretty much in that direction, albeit he is living with his adopted family, and they give him a lot of support, and there's reasons for hope. However, again, I just keep coming back to it. There's zero evidence that he's going to recidivate as a sex offender. He's been out for, the last offense when he was 19, it's now been 10 years or more, and there's no evidence of it. And I don't think that you can establish those elements as required under 496501 based on the record that you have in front of you. It just isn't there. Yes, he's got antisocial behavior, but not as a sex offender. Well, that would be my argument.
I just wanted to ask you about Sorb's assertion that the requested funds to hire Dr. Brown, he didn't do what it was that at least they told the court he was going to do. How does that affect the analysis of his testimony? He didn't really address the mental health piece.
Yeah, and I get that, and it's not particularly clear, I don't think. If you look at the record, the hearing examiner qualifies him as an expert on recidivism. Then the hearing examiner goes about to say, well, you were supposed to have testified with regard to his mental defects and so forth. So yeah, I mean, it's pretty clear. I mean, that's what he said in the record. On the other hand, he's certainly qualified to render an opinion as he did. I suppose he can be criticized for not making explicit findings having to do with the mental health record, but the SORB in their own brief acknowledge that he certainly discusses it, and he goes through a thorough analysis of it. So it's not as if he didn't consider it. It's all part of his analysis toward, and again, recidivism, which is his area. I would say that's his area of expertise as qualified by the hearing examiner.
You have a little more time, but if you don't have anything else that you want to highlight, none of the arguments raised in your brief are weighed. We'll consider all of them.
All right, thank you, Your Honor.
Okay, thank you very much. I just might check. I should have checked with Justices Meade and Blake. No further questions. No, that's okay. No, thank you. No further questions. Thank you very much. Okay, Attorney Chanel.
Good afternoon, Your Honors. David Chennai for the board. You know, it's interesting is in this case, and I think it really comes down to really one sentence in Dr. Brown's evaluation. He said, and I reread it this morning, and that's where I recurred to me how this came about. He said that in sex offender treatment, this individual learned that he's at sexual recidivism risk if he ignores his mental health issues, abuses substances, or fails to pursue adequate treatment for his mental concerns. Now, we know that he's not pursuing, at least the evidence showed he wasn't pursuing treatment anymore. He wasn't taking his medications. Dr. Brown said that if he doesn't take his medications, at some point he's going to become symptomatic. And why that's important is because Dr. Brown also said that should he become symptomatic, that would increase his risk because this individual, according to the doctor, has, because of his mental illnesses, is at risk to commit sex offenses. In fact, he said this individual's mental illnesses probably were involved in the sex offending behavior. And we're also seeing, and you can tell that he's not on his medication or doing his counseling because his behavior is becoming erratic and his drug abuse obviously has been pretty consistent, at least through 2014. And that the doctor said he uses those drugs to self-medicate to deal with his mental health issues. So you've got this instability that's occurring, and it's evidenced by the armed robbery over a Nintendo.
In some ways, it feels like an argument could be made that he's being punished for things that happen after the fact, especially including the death of that child. What case can you point us to where there was one index offense that was sexual in nature, but a level 3 classification without any other sex offense?
Well, I don't have an actual case I can point to, but there are a number of, I'm sure there are not, I know a number of cases where an individual had one sex offense and was made a level 3. I mean, that's pretty common. It depends on, again, the type
Was it an indecent A and B between a 19-year-old and a 15-year-old?
Well, you're saying indecent A and B, he was able to plead down to an indecent A and B. The hearing examiner found that it was a forcible rape.
Right.
Which changes that dynamic. If it was just a plain touching between a 19 and 15-year-old, my guess is we might not even be here. But this was not the case. This was a forcible rape, and that's what the hearing examiner found. And again, that if that was an improper finding, that should have been dealt with back at the Superior Court in 2007. And it clearly either wasn't addressed or the court found in favor of the board on that issue. And again,
but to take this one step further, I think Attorney Fogarty's point is that the change from level 2 to level 3 was not based on any additional criminal behavior that was sexual in nature. That it was only based on other, what we described here today as antisocial behavior.
And so nor does it.
Do you have a case that points to that is similar to that scenario?
We have cases where individuals are reclassified not based on new sexual offenses, but on behaviors that are indicative of sexual behaviors. And the way I say that is because are indicative of the possibility of sexual recidivism. The guidelines are put in place to start predicting which individuals' risks are either high, medium, or low. And it also, the reclassification process is to show an individual whether or not that risk is rising. Evidence of antisocial behavior as evidenced by factor 10, factor 11, factor 12, and factor 13, all of which talk about antisocial behavior being a basic indicator of risks of reoffending. So the board is using its guidelines properly when it says, in this case, this individual's risk is going up because his behaviors his antisocial behaviors are increasing. They're not decreasing. So the board has the authority based on its own regulations to make that determination whether or not his new offenses are sexual in nature isn't the basis, the only basis to go forward with the reclassification. If you look at the reclassification guidelines on regulation 1.32, it lists a number of indicators of increased danger, including in this case, criminal behavior, also it lists violations of probations and incarcerations in excess of 60 days. Now, this case actually worked the way it should. When he had that reckless endangerment of a child and accessory after the fact, in that case, a reclassification was brought at that time, and the hearing examiner didn't increase his risk. At that time, they considered it to be a situation where he actually physically wasn't involved, and therefore they didn't think that that would correlate to a higher risk for reoffense sexually. But since that time, he's been involved with drugs. His lifestyle has become much less stable. And again, he's even robbing a woman at gunpoint for a Nintendo machine. I mean, these are indications that his antisocial behavior is not only rising, that it's rising to a level where the board had the authority to determine that his risk to reoffend is going up with that antisocial behavior. And again, antisocial behavior correlates with recidivism risk for those who have committed sex offenses in the past. Because it's really, if you come down to it, it is the instability of this individual's behavior that makes him a risk. And the fact that he's not in any type of counseling, he's not taking his medications for his mental health issues. And the doctor, even Dr. Brown says that puts him at a sexual recidivism risk. And that's where we are right now. And based on that, the board would state that not only had the authority to bring the action to reclassify him, but the guidelines supported the raising of his status from a 2 to a 3 based on the current evidence and what's going on in this individual's life. And that's essentially my argument. Unless there's any questions, I'd be willing to rest on my brief at this point.
All right, just one moment. I'll check with the other judges, Judge Meade, Judge Blake. No, all right, I see no further questions from the panel. I want to thank you both for your arguments. We'll take the case under advisement and we'll get an answer back to you as soon as possible. Okay.
Right. Thank you.
Meanwhile, I hope both of you stay safe in Western Massachusetts. It's a little safer than being in Boston.
Same to you.
Thank you very much. And you stay